and commits a separate violation of the state medical privacy statutes and also the federal HIPAA laws on your privacy rights, and reveals it to the CPS social worker, which, by the way, the CPS division of DHHS in criminal conspiracy has installed an office in every single hospital birthing center across the whole United States.
Now,
in fact,
Louis, excuse me for interrupting you, but I just kind of went through this with Mark Taylor. He was the first kid shot at Columbine. He lived, he survived, he wrote a book, he appeared in a movie, and he came to see me. And then they picked him up in Arizona in an emergency room, and although this man, he was an adult by this time, he was with his mother, they picked him up and started drugging him and kept him drugged for a year. It took me a year to help get him out. And they're doing this all over. This is what they tried to do to me. They tried to drug me. They did drug me without my permission for 3 months in the hospital. And this is happening all over. Now also, let me, you touched on this drug thing. What they're doing, if you've smoked marijuana, that stays in your system for a while. So it's pretty, 50 million Americans at least have smoked marijuana at one time or another. I believe they stole it, the communists, or the Jews, as the rabbi says. Some people call it communism. We call it Judaism for the masses. And they stole our #1 cash crop, which was hemp, and turned it into a drug, called it marijuana, and they put over 50 million in jail. And you say, and you've got documents, you've got a document that you can carry that shows you can beat a marijuana charge because there's no law against the end user. Can you elucidate on that?
Not just marijuana. My free flyer, folks, go to my website, ultimateusers.com with an S on the end, Ultimate Users with an S, ultimateusers.com. You'll see a picture of the White House covered with marijuana plants. You can also go to prosawinners.net and get a download of my free dope flyers. But these dope flyers, marijuana flyers, actually work for every other drug. I don't care if it's cocaine, methamphetamines, mushrooms, ecstasy. My flyer actually works for all controlled substances because that's what the statute uses. It uses the term or the word controlled substances. It doesn't say marijuana. I wrote the flyer tailored toward marijuana because, you know, there's a lot of politically correct people that wouldn't support me if I was to support people, it being okay to possess methamphetamines or crack cocaine or ecstasy and the so-called bad drugs. But you know what? Here's the thing. The government is actually committing felony kidnapping of people's babies under the color of law. And here's what Black's Law Dictionary, 2nd edition, says: color of law, the appearance or semblance without the substance of legal right, citing a case called McCain versus Des Moines, 174 U.S. Reporter, page 168, 19 Supreme Court Reporter, page 644, edition, page 936, and this is on page 217 of Black's 2nd edition. There is no law that makes it illegal for a pregnant mother to do controlled substances. In fact, Clay just asked for it. Here's the Washington statute in the federal statute.
Go ahead, keep going.
The Washington statute is RCW 69.50.302 subsection C3, and the federal law, the federal statute, is Title 21 of the United States Code, section 822 subsection 2C3. Registration requirements clearly read, quote, C, the following person need not register and may lawfully possess controlled substances under this chapter. There's a semicolon, and in my flyer I put ... and it went straight to subsection 3. That means when you put 3 dots in a legal document, that means you skipped something, you left something out. And I left out subsection 1 and 2 so that I could emphasize the section, which is 3, that provides the 2 classes of people, which is mentioned above, in the plural, the following persons, in the plural. It doesn't say person in the singular. Subsection C clearly refers to two classes of individuals who need not register and may lawfully possess controlled substances under this chapter. And it says in subsection 3, an ultimate user, or, that's a disjunctive word, do you want an apple or an orange? You have a choice of one or the other, but not both. An ultimate user, or a person in possession of any controlled substance pursuant to a lawful order of a practitioner or in lawful possession of a substance included in Schedule 5 of the drugs. Now, the thing I can point out here, registration requirements. Okay, why would this be a registration requirement, and why is this in the pharmaceutical code? Okay, let me explain the two classes of people. All the drug statutes are not in any of the state or federal criminal codes. They are in the state and federal guideline for pharmaceutical, the pharmaceutical code. The pharmaceutical code, to be constitutional, has to specifically name or designate the class of people that's subject to the pharmaceutical code, and to be constitutional, it has to make a reasonable distinction who doesn't fall within the authority of the pharmaceutical code. So who does it apply to? It only applies to a licensed medical practitioner or a licensed pharmacist, a doctor or pharmacist, who's prescribing some kind of a drug, some kind of a cure for some kind of disease. Okay, so the two classes of people is an ultimate user. So what's an ultimate user? Now, I'll point out something to you folks. If you buy a Snicker bar at the grocery store, you're an ultimate user. If you buy a can of Coca-Cola, you're the ultimate user. If you buy a roll of toilet paper, you're the ultimate user. You're the consumer. Okay? Now, if you show this statute, 695302C3 or 21 U.S.C. 822-2C3 to any attorney, lawyer, or judge, these people will look at you in the face and they'll lie to you and say, "Oh, no, you have to have a prescription. You have to have a prescription to be an ultimate user in order to be lawfully possessive." That's a lie. Now,
let me tell you, that's right there is my. I think we've made progress by getting medical marijuana allowed in the states, but I refuse to go to a doctor and pay a doctor to give me a prescription for a weed that can grow in my backyard.
Well, see, here's the thing. All of these drug statutes are in the pharmaceutical code. They're not in the criminal code. Okay, and I've read the entire pharmaceutical code in both state and federal law and discovered that these drug statutes only apply to the licensed medical practitioner or a licensed pharmacist, or the so-called criminal charges they charge you with, they only apply to drug dealers who are not a licensed pharmacist or medical practitioner. There's a statute that prohibits you from manufacturing with intent to distribute. There's also a statute that prohibits you from possessing with intent to distribute. And then there's also a statute that got put on the books because of me here in Washington State about 7-8 years ago, possession of 45 grams or less. But they left out in the title heading the words with intent to distribute. But when I first pulled the session law of the Senate bill and the House bill, I discovered the very first enactment of it clearly stated this is a lesser but possession with intent to distribute. And here's the key factor to this point. There is no statute, if you look at it carefully, there is no other statute in the law books in state or federal law that prohibits you from manufacturing any drug with intent to smoke it yourself. And there is no statute in the books that prohibits anybody from possessing any controlled substance with intent to smoke it themselves, whether it's over 45 grams or less, doesn't matter. So what all the drug dealers need to do, okay, here's the thing. People get pulled over and for whatever reason the cops make a probable cause. They say that you didn't use a turn signal, run a red light. These people are running a license plate check on you. They know who you are before they even pulled you over, and they go, "Oh, Clay Douglas, he's got a prior pot possession charge." So the cop comes up to the window and lies. "I smell marijuana. Get out of the car. I want to search." Now
they have done that. They have done that. I got pulled over in Louisiana, and on my way to a preparedness expo, and the first thing the cop said to me was, "Well, I see you've been arrested for marijuana. You've done time for marijuana." "Yeah, 45 years ago. Yeah, so what?" Well, I got to search your car. I don't think so. You know?
Okay, here's what's illegal. And I do have a flyer, folks. If you go to my other website, ClayDouglas-LuisEwing-CPSChildtheft2, you'll find a flyer called No Random License Plate Checks flyer. You'll also find another one called No Nazi Checkpoints flyer. The cops are violating your rights. They have no right to search your license plate. For if you've been pulled over for an improper turn, not using a turn signal, a busted tail light, speeding, those things are civil infractions. Now, there's two types of arrest statutes in every state statute books. Under the traffic arrest statutes, okay, and also the criminal code, there's an arrest with warrant statute and an arrest without a warrant statute. In Washington State, the arrest without warrant statute is RCW 10.31.100. It has three subsections. Subsection 2A, B, and C specifically enumerates and lists every statutory offense in Washington State for which the police officer has the legal or lawful authority to arrest and take you into custody. Now keep in mind, folks, you are under arrest when the lights come on. The reason you're under arrest is because you're not free to leave. That's the first thing you should ask a cop. Well, officer, you know, am I under arrest? Am I free to leave? The cop will lie to you and say, oh no, you're being detained. Well, you hand him my arrest me or free me flyer, which at the very top of the page contains the dictionary definition of detained, which uses the word arrest, which I bolded, capitalized, and highlighted. It uses the word arrest to define it. So you tell the cop again, no, officers, don't play any games with me. You either tell me that I'm free to leave or I'm under arrest, or I'm stepping on the gas and leaving you here eating my dust. Okay, then the cops say, fine, you're under arrest. Okay, well, now I'm invoking my right to remain silent. Well, you have to answer my questions first. Well, no, I have a right to remain silent. And I have a Miranda flyer, which contains the case law that says your right to remain silent exists before the cop came to talk to you. Okay? The cop isn't the one who gives you your Fifth Amendment right to remain silent. Okay? Under the First Amendment, you have the right to the freedom of speech, which inversely gives you the right or the freedom not to speak. And most people talk too much to the cops. I recommend you don't talk to them too much and just say, I'm invoking my right to remain silent. I'm not going to talk to you. Okay, but the license plate check is illegal. Look in your state statute books. You will not find a statute anywhere that allows them to run a license plate check. Okay, and here's what they're doing. Okay, they're miking in and miking out of two separate databases. First thing they do is they run your license plate into the Department of Licensing records to find out the name and address of the registered owner. Then they mic out of that database and they mic into a second database in Washington. They call it the WASIC, the Washington Criminal Information System. They do have a nationwide one. They're all plugged in electronically now. But guess what? If you've been pulled over for speeding or running a red light, under Terry versus Ohio, which is the best and worst case in the United States, that defines what a Terry stop is state reasonable, articulable facts to give him probable cause or reasonable belief that you were either committing a crime or about to commit a crime. Well, Judge William Rehnquist, in a case called Patrick Knowles versus the state of Iowa, was quoted nationwide in all the newspapers telling the cops who found marijuana, guns, and money in a glove box of some Mexicans. They were jealous, these racist, prejudiced white guys. These homies pull them over. They got to be drug dealers, you know. They're just jealous of the Mexicans who were, you know, businessmen or whatever. And Judge William Rehnquist said, what further evidence of speeding could you possibly hope to find in the glove box? The act of speeding was committed at the time that you stopped them. Under the traffic arrest statutes, you were only authorized to detain them no longer than necessary than it takes to issue them a citation and notice to appear. You didn't have legal authority to search their glove box. And here's the key thing, folks. You can only be searched incident to a lawful custodial arrest. You cannot be searched incident to what is required under the law to be a non-custodial arrest. Now, if you can't go to jail, to the county jail, for committing a civil infraction, which, by the way, folks, a civil infraction is not a crime. It's a civil infraction. That's why they call it civil. Okay? You cannot go to jail for being found guilty or committing a civil infraction. If you're running a red light and the cop saw it, he has the only authority. Look for these words in the do word search on the statutes. You'll find the word in his or her presence. The statutes, the traffic arrest statute says a police officer has authority to stop and detain you no longer than reasonably necessary than it takes to issue a citation and notice to appear for any offense committed in his or her presence. In Washington State, the traffic arrest statute is 46-64-015. And our state Supreme Court, in a case called State versus Redding, reaffirmed an appellate court decision called State versus Stortron, spelled S-T-O-E-R-T-R-O-N, State versus Stortron, reaffirmed by State versus Redding, R-E-D-D-I-N-G. The state Supreme Court said, this is a traffic stop. We can't look at the criminal code, RCW 1031-100, like they did in State versus Stortron. We have to look to the traffic arrest statutes. And they scrutinized RCW 46-64-015, and they held that this statute does not contain any wording or language to the effect that would even purport to give or remotely give any authority, lawful or legal or otherwise, to a police officer to arrest and take into custody anybody for driving while license suspended. In fact, driving while license suspended is not listed in the arrest without a warrant statute in subsection 2A, B, or C, where it uses the word and take into custody. It is listed in the third subsection of 1031-100, which uses the word may arrest, and that's the key thing, folks. They may arrest you. That means the lights come on, you're not free to leave. He can stop you no longer than reasonably necessary than it takes to issue a citation notice to appear. He may arrest you, but subsection 3 does not use the words and take into custody, as does the immediately preceding subsection 2. Subsection 2, A, B, and C uses the word arrest and take into custody. And that's RCW 10.31.100. Look at that section. Subsection 2 uses the word and take into custody. Subsection 3 drops off the word and take into custody and only uses the word may arrest. Okay, and I do have a stop arrest flyer that cites the exact, gives you the exact case law citation, the page number, the and other cases.
Alright.
Hold on. Go ahead.
Yeah, hold on just a second, because there's something else I want to ask you about. This whole thing, this shooting, I don't know why we're getting so much play on this shooting, the killing of 19 little children, when we didn't get that much play on the government killing 17 little children at Waco. But this is being used now to create another class of crime. What I'm understanding from what you are telling me right now.
Let's arm the teachers.
Yeah, that would work. Arm the pilots, arm the stewardesses. Just a moment, boys. Hold on, just a moment here. Let me finish this thought here. What is being happened now? I've always told people that I'm the canary in the coal mine, because when they will come after me first. And I want to share what a Connecticut cop just said, and I've got this up on my internet. I want to play it again. This was the most blocked show that I've got. They want to come after people like you and I, and they're doing it this way. Listen to this Connecticut police spokesman from Newtown. They are trying to capitalize on this shooting to take your guns away, but more than that, they know they're going to have a little problem taking the guns, so they want to arrest you or us for giving you the correct information. Listen to this.
One thing that's becoming somewhat of a concern, and that is misinformation that's being posted on social media sites. It is important to know that we have discussed with federal authorities that these issues are crimes. They will be investigated statewide and federally, and prosecution will take place when people perpetrating this information are identified. Again, all information relative to this case is coming from these microphones, and any information coming from other sources cannot be confirmed, and in many cases it's been found is inaccurate. So I simply, that's the newest twist today, that we want to make sure that's perfectly clear that social media websites that contain information relative to this case are not being posted by the Connecticut State Police, are not being posted by the Newtown Police, are not being posted by any authorities in this case. So any of that information and people that are putting that information up there in any manner, all right, that can be construed as a violation of state or federal law, will be prosecuted. Will be.
How about that? Now, hang on a second. While I renew my coffee, let me in relation to this conversation that we've been having here, let me see what I've got here. I've still got a few more minutes here. Let me do a couple of lines out of a song, because again, what's happening here, folks, is the government, the CIA, the Mossad, the intelligence agencies are bringing all of the illegal drugs into this country. Our troops are being used to guard the opium poppy fields because those nasty old Taliban were destroying them. Well, the pharmaceutical companies have to have their heroin, they have to have their opium, they have to have that. Now let me do this.
Times they ain't like nothing they used to be. From Rocky Mountain to Northeast Tennessee, where the river flows with a dusty cold disease, and the babies whine 'cause they can't find nothing to eat. But mama, she ain't hungry no more. She's waiting for a knock on the trailer door. It's gonna rock you like a hurricane. It's gonna rock you till you lose sleep. It's gonna rock you till you're out of a job. It's gonna rock you till you're out on the street. It's gonna rock you till you're down on your knees. It's gonna have you begging pretty please. It's gonna rock you like a hurricane. Methamphetamine.
Yeah, a little tune there by Old Crow Medicine Show. And Louis, I mean, this is just this is the latest drug. More people have died from pharmaceutical drugs than all of the methamphetamine, heroin, or cocaine in the world.
Yep.
So
this whole gun thing, they want to disarm us. That way they can round us up. Nobody will be able to resist. See, they fear being shot. They don't want to be shot when they come to pick. There's so many American people right now that own guns. You know, they say that, who was the Japanese leader a long time ago that said that they would never invade America because there's a gun behind every blade of grass?
that was the Japanese, and that's why the Chinese government, communist government, Jewish control, Jewish setup, they say, oh, the school shooting now, we need gun control, we need gun confiscation, Americans need to turn in their guns. This is the Chinese government advising the United States about it.
You know, they've got enough Chinese people that they could literally walk into the ocean voluntarily committing suicide and drown and pile up enough Chinese bodies that they could actually form a human land bridge across the ocean and walk over here. And still have enough Chinese to do
and
that.
they are not above doing that. I mean, they were sacrificed, the Chinese people, the same way they sacrificed their own Jewish people in World War II in Germany. They did it.
Well, you know, if they had armed every single one of those school teachers, maybe that terrorist or whoever he was, you know, that kid, maybe he would have got, you know, 2 or 3 of the children, but one of the school teachers would have got him before he got any more. See, this is why we need to arm school teachers, and all these pansies and homosexuals, we need to get them out of our public schools because they'd be too scared to hold a gun. And you know,
by the way, let me just interrupt you. Let me interrupt you for just a second. In Connecticut, over 200 teachers have been charged or fired for molesting their students, children.
And it's surprising. The funny thing is, it's more and more females. Females having sex with young boys.
Well, you know, I mean, certainly, that happened to me. I was 14 years old, and I thought it was just sex. I didn't realize I was being molested, and I kind of enjoyed it. She did too. So, you know, go figure.
Every high school boy's fantasy is to do with a cute school teacher.
Well, I've made most of my fantasies come true at one point or another.
Okay, that's good. Well, back to the subject of law. When I'm exposing about CPS.
Yes, let's talk about CPS.
Okay, there is no state or federal law in existence that prohibits anybody from doing any drug in any quantity, and since I already pointed out the 2 classes of people who can lawfully possess, this begs the question, what is an ultimate user? Well, the definition of an ultimate user in Washington statutes is found at RCW 69.50.101 subsection BB, and in federal law, the definition of ultimate user is found at Title 21 in the United States Code. It's called 21 USC subsection 802 subsection 27. So all you folks out there who don't know how to look this up, Google the term United States Code. The Cornell University has the United States Code online. Just Google United States Code. You'll find the Cornell University law site for the United States Code. You type in on the title 21, and in the chapter or the section you type in section 802, and you go down to subsection 27, and ultimate user is defined in quotation marks, means an individual who lawfully possesses a controlled substance for the individual's own use or for the use of a member of the individual's household, which could be the baby in your stomach, because obviously the baby in your stomach is a member of you as an individual of your household. Your baby is a member of your household. Or for administering to an animal owned by the individual or by a member of the individual. People out there are like going, no, that's not right. We can't have pregnant women doing drugs. Well, you know what? This is not a moral issue. This is a legal issue. Whether you like it or not, you know, and I understand, you know, I agree pregnant mothers shouldn't be doing cocaine, shouldn't be doing meth and ecstasy and all that other shit. Okay, I agree with you. But right now, there is no law prohibiting from doing so.
Well,
okay,
you
so
know, there's common sense, and frankly, you know, I've done a lot of cocaine in my life, and I stopped doing it when I learned the CIA was making all the money off of it.
Okay, so here's something to think about. There's no law in state or federal statutes that prohibits any pregnant woman from doing drugs. Okay, and this begs the question, can you be penalized? Can you have your child, your newborn baby, ripped out of your arms because you tested positive for drugs when both state and federal laws specifically allow you to do drugs? Can you be penalized for something both state law allows and something that federal law allows? No, you can't. In fact, these people could sue, not only sue